Dear students, welcome back to Foundations of Law, and that would be HOX 6061. So today we'll be talking about common law system. If you may recollect, we spoke about the Romano-Germanic system, which is also a civil law system, last week. So the common law system is something that I'll be talking a bit in detail about today. And well, of course, it's based on English law, and so we'll be looking at the history of the English law system, the structure of English law, the sources of English law, and the simple, straightforward things, just like in the previous lecture. So we follow that same chronology, and well, usually, sometimes in this lecture series, before the coronavirus thing started out, I used to, grab hold of some visiting professor or lawyer from the United States, for example, to give us an interesting insight into how things are done from a US perspective, because remember, common law covers them as well. Well, that's not going to be happening this year, unfortunately. I do have some lecture notes from previous terms, previous years. So if you're interested, well, I could put them up. Otherwise, well, from the exam point of view, this should be good enough. So the common law system, and of course, it's a peculiarity of English-speaking countries or those countries which have political links with England. And of course, if you remember the colonial history period, then well, Great Britain ruled, almost everywhere, and so there was a saying that the sun never sets on the British Empire, which would basically mean now that a lot of countries were covered by this common law system and the English approach towards legal jurisdictions and legal jurisprudence. Now, this is, of course, interesting to remember because after the end of this lecture, hopefully you'll get an idea about why the English or the British think that they are different, and why Brexit and all of these things are happening. It's because there are some very fundamental differences in the jurisprudence of the British Isles and the way they see things. So it can be quite different from the Romano-Germanic system. Of course, in the end, it's surprising. Both of them are Western legal philosophies, and you may start off with the English common law system here or the Romano-Germanic system here, but eventually the end result very often is the same. It's just that they have a different approach towards it. So let's look at some of this interesting jurisprudence history over here and see how things are. So it's very important to keep in mind that England, and I'm stressing upon England over here, there is England, Scotland, Wales, Northern Ireland, but England is the key focus area over here. It's the predominant part of the system. And they've had very limited contacts historically with the European mainland, if you could call it so. All right. So there were four basic principal periods, and if you look at them historically, there's before the Norman conquest, and there were a lot of Englishwomen staying there in England and the Isles, and of course in Scotland and in Wales there were the Scots and the Welsh people as well, and they were quite independent from the mainland European influences. Of course, the Romans had gone there, but they didn't really consider much about the way things were in England. It was just famous for its tin mines and things like that. So, well, you have all these stories of this the Knights of the Round Table, those sort of things. So that's that point of time. This was before the Norman conquest. So we're looking at everything before the year 1066. So that's this whole period. Of course, there were some aspects. Christianity had arrived after the Romans had left, and then there were also Viking raids and influence of the Norse people and things like that. But that's how things were. There were local customs, and it was the way it was running. Then came 1066, and that's when William the Conqueror and the Normans attacked England from the coast of Normandy, and they succeeded in the Battle of Hastings in defeating the English king. I believe King Harold. Well, anyway, this is not a history class. This is a law class. So what we're looking at over here now is a situation whereby the tribal rules on all those little things that they had going on in that island came to an end, and you had feudalism which was installed, brought in from France, northern France, and there were new feudal courts. There was of course the king and the king's court. Ordinary people had no access to the king's court, and there were all of these sheriffs and knights all around. And that's where the story starts of Robin Hood and the Sheriff of Nottingham and all those sort of things. So if you had a problem, serious problem, well, you had to go to the local sheriff or the local landlords, feudal lords, if you could call them so. There was really no chance that you could take a horse and go to London and go to the king's or the queen's palace. That never existed. So from the 13th century onwards, of course, there was a bit of autonomy granted to judicial bodies, and you had the courts of Westminster and some sort of bureaucratization taking place, and their jurisdiction was enlarged. And of course, now people could approach these courts instead of going to the king or the queen directly. Again, in this historical aspect, you should keep in mind how it is very different from what happened in the Romano-Germanic system, where things were very different in France, in Germany, in Italy, etc. All right. Well, not Germany as such, but German-speaking countries, including Prussia, and of course, English common law was established during this 13th century period, and the whole emphasis was already on things like having access to the court system. And even though these were restricted in a certain way, the emphasis became almost entirely on procedure. So this is what you see from the 13th century onwards, and procedure overrode everything else. The idea was, if the procedure is correct, you'll get the right answer eventually. So it's like, let's say you want to go from Tallinn to Helsinki. So if I tell you the procedure is you go to Tallinn the harbor, and you take a ferry, and that ferry will take you to Helsinki. Well, that's it. You follow that route, and you're going to reach Helsinki. There's no way you can't reach Helsinki unless something happens to the ship or something, right? So that's this magnetic power of procedure. Somehow the belief that if you follow the procedure, everything falls into place. And this viewpoint is still prevalent, of course, and it has pervaded into every aspect. Whether it is evidence law, for example, how the courts function, how the administrative bodies function, everything depends on procedure. Procedure is correct, everything falls into place. Procedure is even slightly wrong, well, that would vitiate the entire proceedings, and then you have a serious problem. So of course, on the one hand, this caused a lot of rigidity in the system, but surprisingly, it also gave a lot of power to the courts to interpret in different ways how things were done. So procedure is the key, number one. Number two is, of course, the historical influence. Number three is there's no distinction between public and private law because, well, the king or the queen owns all of Great Britain, and if you mess with something, you're messing with the king or queen's power. So that's the way they look at it. So in that situation, there's no public, there's no private. It's all down to the royalty. And then of course, if you do something that is incorrect or wrong, basically you have to answer to Buckingham Palace or Tower of London, because that's the way the power structure was. So if you don't obey the order of a judge, Well, it means you're disobeying the king. How do you beat that logic? So, of course, this meant a lot of fundamental differences between common law, English common law as we see it, and Romano-Germanic system of law, which we looked at last time. Because of these early developments, already you can see that Roman law or its allure or its fascination does not exist. Now compare that with last time's lecture where we saw how in the 13th century people began to look up to Roman law as a source of inspiration. Well, that did not happen in England. So the royal courts were, of course, more political rather than judicial, and well, they had this own way of looking at things, and of course, this caused a lot of issues, but also a lot of developments of principles that were completely at variance with what you have in the European civil law Romano-Germanic system as such. Now, because of the strict compliance with formalist procedures, you ended up with a situation where things became too rigid, and of course, this resulted in the pendulum swinging the other way. And so you can notice how equity grew, and equity is now a very interesting situation because here you have, yes, okay, you did not follow the procedure, very bad, but end of the day, it's all about justice. And can we deny you justice simply because you did not follow the procedure? All right. So let's give an example of this. In English common law, you have writs. So there is writ of certiorari, writ of habeas corpus, and in all of these sort of writs. So what's the writ of habeas corpus? For example, well, your relative is missing. The cops came home, they took your relative, and now you don't know where your relative is. You went to the police station and nobody's answering your questions. So now you go to a court of law and you say, well, I'm filing a writ of habeas corpus. And basically what it is that it's requesting the judge to order the police or the administration to produce this missing person before the court. And then the court will decide, the judge will decide whether this person is, has been kidnapped or is away from somebody on their own free will or volition or whatever. So basically it all depends on the writ you file. If you file a writ of mandamus or a writ of certiorari, then you're in the wrong pigeonhole because that's the procedure. And of course, what if you do something wrong with the paperwork and instead of ticking X, you tick Y on the boxes, and so now you did not follow the procedure 100%. All right, there's a 5% fault somewhere. Now, old school way of looking at this would have been, well, you did not follow the procedure, so out of the window. But if you look at equity, then equity sort of brings in this modern touch to it, and it says, hey, let's also try to look at this situation from a humane point of view. So you should not always be too strict, and procedures are important, procedures are good, but sometimes there should be some sort of leeway so that there's some flexibility in the system. Otherwise, too many innocents will get in trouble and too many guilty will get away free because procedure is king, and if that is the situation, then that's not good for society either. And then lastly, you have the modern period, 19th and 20th centuries, where things began to shift quite a lot. Now remember, in the United Kingdom, you still don't have a constitution, a written constitution. I mean, can you imagine there is no written constitution? Yes, there are these Magna Carta and there are these rights and all of these things somewhere, but no written constitution. So instead, what you have is this series of understandings of how things should be, how they should be run. Of course, you had this parliament became supreme after the English Civil War, and so you have a lot of contradictions and a lot of too much information sometimes, overload of information, but no written constitution. But this began to change in certain respects. For example, procedure was changed, and then there was also this idea of having more statutes and regulations. instead of just relying on case laws. Then also administrative tribunals increased. So you already see from the 18th century, end of the 18th century, early 19th century onwards, and especially after World War One, and then of course World War Two, where all these administrative tribunals, administrative law, all of these things began to develop. And so a lot of this is very similar to civil law, Romano-Germanic systems. So you have something which started off completely different, but because of modern times, you see this sort of move towards some sort of synchronization between common law and civil law systems. Now remember again, civil law when I talk about over here is Romano-Germanic. Civil law also is the name for a situation where it's civil law versus criminal law. So that's different. So keep this in mind. As young lawyers, some things you should not mix up, and these sort of names and understandings of them and the different meanings should be kept in mind. So what's the structure of English law? Of course, number one, no distinction between public and private law. Nothing major, at least, especially. Number two, there are some important concepts: trust, bailment, estoppel, consideration, trespass, which wouldn't mean much in a civil law, French or German context as such. So now what could be a trust? An example of this, well, I'll talk about this, of course, it's coming soon here. So there are legal divisions and concepts, and then of course, law studies, law courses, law research and all that was a bit of a late bloomer, unlike in the case of Renaissance Europe, and already in the 13th century, 12th century, you had law universities being set up in Italy, for example. We had a visitor from Sierra University, and he said that that's the first law university in all of Europe. It's in Italy. Well, that didn't really happen in Oxford and Cambridge until much later on, almost in the 17th century, if you could call it so. And so, you didn't have to have a law degree to be a lawyer. Now this is, of course, this is quite complicated. So what that basically meant was, you worked and you got practical experience, and that was more important than just reading some books in a university. So the idea of getting a law training was, there's a court system, there are senior lawyers, you become a junior under that lawyer, you carry his or her books for him or her, and then do all those things. And talking about 300 years ago, 200 years ago, so mostly male lawyers. And at the end of it all, there is a bar exam, and you have to do that after 2 or 3 years of traineeship. And then you become a qualified lawyer. And of course, they had their inner temple, outer temple, and all of those sort of societies. Number two, procedure and evidence was very important. So for example, you have some concepts like fruit of a poisoned tree is poisonous. What the hell does that mean? Well, let's just say I'm a police officer and you are suspected of a crime, so I have arrested you, and I don't have patience to investigate properly, so I just beat you a couple of times, and you confess and you say yes, you sign on the paper and you agree to whatever I wrote on that paper. And I go to the court and I tell the judge, here's the paper, and this person has admitted that he or she has committed the crime. Now the judge will ask, or the magistrate will ask this person, is that true? And if he or she says, no, it's not true, Pawan, this police officer beat me up, and that's why I agreed to whatever he said. Now you have a problem here. The problem here is this evidence is tainted. So if this evidence is tainted, then everything gets messed up, and now the procedure has not been followed properly. And that's why this trial will have to, stop right now, because this is not the way to conduct an investigation or a criminal proceeding or a trial. And because of my fault and because of my non-adherence to the rules, the evidence that has been collected by me is now no longer admissible in a court of law. And since I'm a police officer, what that means is the evidence collected by the police is wrong, it is unjustifiable, it is illegal, and so now this person is innocent because I, on behalf of the prosecution, have not been able to prove that this person is innocent or guilty beyond innocence. All right, so you have these sort of situations here. So procedure and the way evidence is collected is also seen as a very important aspect. And then, of course, equity is something that is especially prevalent, plays a very important role in the English law system. So the legal divisions and concepts that we are still going on that. So for example, if there's a breach of contract, as we call law of obligations in Estonia or Finland or France or Germany. Now in this case, of course, you could claim damages under common law, but that may not be enough. So equity would demand that you should also demand that there is a degree of specific performance. Now what would that mean? Well, that would mean you are my student. Let's presume we are in the English law system here. And I promise you that you study your course properly and you'll get the marks and you'll pass. And well, I changed the rules midway and now I have failed you. So of course you could sue me for damages, but that's not good enough. You also require that I should follow the original rules, and based on those rules I should pass you. So that's specific performance. It was very specifically seen in cases of, let's say you hire somebody to paint your portrait, and now this person takes money from you, and he's very busy, and so of course he's Michelangelo or whoever, he's very busy, and so he tells his assistant, the assistant can draw your portrait and Michelangelo will come later and put some crayon marks on it and the signature down. Now of course I could say, no, that's not good enough. I hired you, you're a professional, and you should paint my portrait. And if that can't work out, then of course I want my money back, right? That's one part. Number two, I now have to find a new painter, artist, in a short notice. So that costs me a bit more money. So I want that money also, fine. But I can also say, no, there's only one Michelangelo, and what the hell, you agreed to this, now you have to do it. So of course, in this situation, you can have specific performance. So you see how this goes, not only under common law as simple damages, but goes to the next level, which is specific performance. Trials under common law system normally would have meant that it's like a ping pong match. The judge is neutral, the judge is just a referee. You are on behalf of the plaintiff, I am on behalf of the defendant, and well, you start and you say blah blah blah, and I counter that and I say no no no, and then you say yes yes yes, and then I say why whatever, right? So it's a battle going on here, and may the best party win. And the judge's job basically is to make sure that as a referee, I don't break the rules or you don't break the rules. So it's a contest. And this is very different from how you would have it under civil law, where of course the judge would play a more inquisitorial role and would be interested in making sure that all the things are properly done. So of course that's how it used to be, but of course with equity you also have a situation where now under common law the judge not only is a referee but can also interfere, sometimes intervene, and can force some evidence to be disclosed and things like that. So these are important things to keep in mind. Other concepts over here are aspects which you don't often see in civil law. So now let's say I sign a contract, and so I agree to give my car to you, all right? And so, or you agree to give the car to me, and we sign a contract, and so you're selling your car to me for 1,500 euros. Well, so I have a contract and you agreed to it, and you're a grown-up person, I'm a grown-up person, so that's the end of the story. But what if later you were to say that no, you want to go back on this contract because there are certain vitiating factors, duress, coercion, undue influence, fraud, misrepresentation, mistake. So all of these are very strange concepts. It could be like, I am your lecturer, so I am forcing you somehow to agree to my unreasonable demands. Your car is worth 25,000 euros and you're selling it to me for 1,500, because obviously I'm in a position that I can influence you unduly and cause duress to you. So of course, these are situations which the court would now interfere in, because I'm taking unfair advantage of myself. So these are all some concepts that are very interesting. Morality, equity, all of these sort of come in over here because of this mismatch of things. So the point here is it's very different from the very structured and regimented and well organized civil law system. Instead, what you have in common law is things just somehow fall into place, and sometimes you don't understand half the time how did it happen, but eventually it sort of got sorted out. So one such concept here would be a trust, and a trust is a very fascinating concept. Started out under common law. Of course, you now see it in other countries also, other legal systems. But simplistically speaking, how did this work out? Well, there's a trust, and there is a trustee, and of course there's a settler. The settler is the one who gives money to the trust, and the trustees take care of the trust money, and they do all of this so that the beneficiaries can benefit over a period of time. Now, how would this have worked out? Let's say, well, you're Richard the Lionheart or whatever, and then you have to go, or you're a knight, and that's the 12th century, 13th century England, and you have to go and fight the Holy Crusades war. Now you have a castle, you have servants, you have lands, you have a wife and children. Now the problem here is, in those times, women could not own property, so, well, only a man could own property. So what would this particular soldier do now? I mean, not a soldier, he's more like a general, but he has to go and fight a war, and who will take care of the wife and kids? So how is the legal certainty going to be maintained? So that's where a trust historically came in. So the settler would be this particular knight and he would appoint some beneficiaries, maybe his friends or relatives or some people, all males of course, and he would give all his wealth to them, and it's under their control. And of course they have strict orders that this wealth has to be used only for the benefit of the wife and the children. So these are the beneficiaries. Now, of course, why is this relevant in today's world? Well, this can be quite fascinating, because let's say I have all this money, 25 trillion euros, and we'll have to pay tax on it. So what do I do? Well, I put this money into a trust, and the trust has trustees, and of course the money does not belong to the trustees. Yes, the trustees have to use this money for the benefit of the beneficiaries. Could be me, could be my children, my other family members, whoever. But this money does not belong to them either, or to me now, right? It's just that the beneficiary gets maybe 1 million euros every year as payment, and the trustee's job is to make sure that this money never gets over. So of course the trustee keeps on putting this money into bonds or shares or debentures or other ways of earning money. So of course in the bank deposits or whatever. So what you end up with is a situation where, whose money is it? If it's not my money, it's not your money, it's some trust's money, then who pays the taxes? And of course, many countries under the common law system have the distinction between a public trust and a private trust. So if you have a public trust and you have a public charitable hospital for dogs or for poor people or something, then it's a charitable cause. And of course, all of these donations to this trust and a lot of the work it does would be tax-free. So you can see how this can work as a very effective tax avoidance mechanism. That was never the intention, but this can be a situation that can arise And it's a very unique concept which has now started being exporting to other started being exported to other legal jurisdictions, and other legal systems are accepting it. So it's very interesting to read more about trusts and how they work. And it's a very English common law way of thinking, and very abstract in a very strange way, very practical, but at the same time very nebulous. So you can have, of course, set up a trust, and then this trust could invest in some property, or some shares in another trust, or something else. And you can have trusts in 5 different countries. You could have something in London, and then something in Dubai, and then something in the British Cayman Islands, British Virgin Islands, and a lot of these tax-free regimes. And then you can do a lot of crazy things, and at the end of it, nobody understands where the money is, where it comes from, where it goes. And of course, in that situation, how do you tax somebody? So that's a very interesting aspect about this system. So that's trusts. That was one such thing. There are, of course, others also, like estoppel. Estoppel would mean if I make you believe something, and based on that belief you do something, then I cannot change my mind and say, well, no, new plan. I can't do that. So estoppel would be, for example, I tell you that you do the exam, and you study well for that, and you do the 2 homework assignments, and then it's pass or fail. So you get 51 and above, you pass, and if you get 50 or less, then you fail. So that's what I've told you right from the beginning. Now let's say in December I change my mind and I say, no, this is going to be a graded exam, and it's going to be 1, 2, 3, 4, 5. And if you don't get 75% attendance, even though it's coronavirus, and if you don't do all of those things, then you cannot pass, you will fail. Now, what you could in that case do is, under English common law, you could sue me and say, no, this is estoppel, and I cannot change my mind because you followed all the instructions, and now you are at a disadvantage because basically whatever I told you has now been changed, and that's not acceptable. Another aspect would be consideration. Consideration is very important also from common law and contract law point of view. So I cannot sell you something for free. There has to be some consideration. There has to be some money. If it's for free, then there's something seriously wrong here, because why would I give you something for free? Unless, of course, there is natural love and affection. You are my, spouse, or you are a close family member. But otherwise, consideration is very important. And then there are concepts like trespass. And again, all of these are very interesting common law concepts, which you also now see in many other legal jurisprudence areas. So of course, there are also there's also a lot of importance given to law of procedure and evidence, as I informed you how evidence law is very important and the procedure should be followed. And judges usually are people who have worked as lawyers for 10, 15, 20 years and have done important cases and done important things. Based on that, they are selected as judges. So that's very different from a civil law system where you pass out of law school and you do your bar exams, and then you're bright and you've written some written some articles or some book journals or something, and then you become a judge immediately after doing a judge exam, and now you are a judge at the age of 26 or 27 or 25, and then you go up the ranks. Well, that would not be acceptable under English common law, because under English common law, well, you're not really a lawyer unless you are 40 plus years of age, because until then you don't have the experience. So experience is more important than anything else. And so in that sort of situation, it's after you study your law degree and then you practice law, and not just practice, but practice very successfully. And then after 10, 15 years, you may be elevated from the post of a lawyer to a judge. So of course, these are important things to keep in mind. Also, well, procedure is so designed that you have a simple trial in which you have questions And the answer is yes or no. So you frame the issues, and that's very important under common law. And so basically, there's a trademark dispute, and I'm using a trademark which you claim is yours. And so the question that comes up here is you frame the issues. So question number one would be, are the two trademarks similar? Yes or no, right? I mean, that's the way the answer would be. Question number two is, who started using the trademark first? Pawan or this person? So yes or no. Question number three would be, well, if both people are using the same trademark or similar trademark, is some damage being caused, and to whom it is being caused? Yes or no. Yeah, again, so you have very simplistic questions which are framed, and so the answers can be quite straightforward. Of course, there are lawyers in between, and so now everything gets very super complicated, but that's how you have in the US Apple versus Samsung, a suit worth hundreds of millions of dollars, and it's a jury trial. And who's on the jury? People who have no legal experience, because in the end, the truth is the truth, and law is supposed to be simple, and you should be able to answer it in the terms of yes or no. All right. So there are public hearings, oral system, there are witnesses, and there's a process for it. So you have an examination in chief, you have a cross-examination, you have a re-examination, and you have the burden of proof, the onus of proof. So all of these are concepts that you see from this English common law system. And so based on this, of course, certain kinds of evidence can be excluded, even though they may be very important, simply as I gave the example that they were not collected properly. So this attitude towards procedure is very important. And of course comes the enforcement of judicial decisions, which is again an area in itself under English common law. So these are all aspects that you must remember. So when you look at English law judgments, they are super long. You have the ratio decidendi, which would be the most important elements, and then the obiter dicta, which is, by the way, this and that. So if you read any of these high court judgments in the UK or the US Supreme Court judgments, for example, long, 100 pages, 200 pages, never ending. So what are the sources of English law? Well, of course, the courts are very important because of legal precedents. They are very important, but there are hierarchy of courts. So the Supreme Court's decision would be binding on all the lower courts. The High Court's decision would be binding on all the lower courts, and then so on and so forth. All right. So the High Court cannot tell the Supreme Court what to do, but the Supreme Court can tell the lower courts what to do. And you can see that in the hierarchy that is here in the map as well, in the graph as well. So that's number one, very important. Number two would be statutory law. And of course, there are some of these things that have come in effect more and more. Then there are customs, and customs are an important source. And then come legal writing and reason. And so these are the elements. Based on these, you have the English common law system. And well, I wish I could have shared some more information with you about this, but maybe I can dig up. Well, I have some old previous lectures of visitors from the United States, etc. It's just that I don't want to over mess it up. But if you want to read, it's already here in the reading material. There are some notes available where we can study more about the English common law system. All right. So thank you for your time. And next week, we will start with Islamic law and understand some of the structures that go into it. So until then, have a good day. Goodbye, and a good week as well.